Good evening, dear students, and welcome to civics class once again. So, dear students, according to our latest syllabus, we have only 4 lessons in civics, and this is the last lesson according to our syllabus. That is judiciary, and we will learn about judiciary and the Supreme Court in this lesson. Judiciary is the third organ of the government. Legislature, executive and judiciary are the 3 organs. Already we have learned about legislature and executive, and now it is judiciary. The organ which is protecting the constitution, safeguarding the fundamental rights, it is judiciary, the third organ of the government. And we will learn about the Supreme Court and its composition, then the various functions of the Supreme Court of India. Okay, Supreme Court of India and the various functions of Supreme Court of India. Okay, so at present the Supreme Court has composed of 33 judges and 1 Chief Justice, 33 plus 1. President of India can appoint all these judges. Okay. President of India can appoint all the judges including the Chief Justice of India. And for that person must possess certain qualifications. A person is not qualified for appointment as a judge of the Supreme Court unless he is a citizen of India and has been for at least 5 years a judge of a high court or of 2 or more such courts in succession, or has been for at least 10 years an advocate of high court or of 2 or more such courts in succession, or is in the opinion of the President a distinguished jurist. Jurist means an expert in law. So a person must possess any 2. Okay, he must be citizen of India, and one more qualification, has been for at least 5 years a judge of a high court, or has been for at least 10 years an advocate of a high court, or according to the opinion of the President, he is a distinguished jurist. If a person possesses these qualifications, then the President can consider him for the appointment as a judge of the Supreme Court. Okay? So, please remember now 33 plus 1, that is the present composed of the Supreme Court. Okay? And now, every judge of the Supreme Court is appointed by the President of India in consultation with the judges of Supreme Court and of High Courts besides the Council of Ministers. Okay, President of India will consult with some people in the country. In case of appointment of a judge other than a Chief Justice, the Chief Justice of India shall be consulted. Okay, he will consult with the Chief Justice of India. Suppose the President of India is going to appoint a judge in the Supreme. Before that appointment, he will consult it with the President of India. Okay. And then when the Chief Justice is unable to perform the duties of his office by reason of absence or otherwise, the President may appoint another judge of the Supreme Court as the acting Chief Justice. So what do you mean by acting Chief Justice? Suppose the Chief Justice of India is not able to attend his office due to some reason. So he can take a leave. No. During that time, okay, the President of India can appoint another judge of the Supreme Court as the acting Chief Justice, not the Chief Justice, but acting Chief Justice. Okay. And the President of India can appoint ad hoc judges also. Not the President. The Chief Justice may appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a period as may be necessary. Ad hoc means created for a particular purpose only. That is ad hoc, for a particular purpose. The Chief Justice of the Supreme Court can appoint ad hoc judges. Such appointments are made with the consent of the President of India and after consultation with the Chief Justice of the High Court concerned. Before the appointment, the Chief Justice will consult with the President of India and the Chief Justice of the High Court concerned. The Chief Justice may at any time, with the previous consent of the President, request attendance of retired judges of Supreme Court or High Court to act as a judge of the Supreme Court. Okay? These provisions are there in the Constitution. And what is the term of office of a judge? A judge of the Supreme Court shall hold office until he attains the age of 65 years. Okay? Please remember, until he attains the age of 65. If this question is don't be in confusion, a judge of the Supreme Court shall hold office until he attains the age of 65 years. Okay, until he attains the age of 65 years, a retirement age. A judge may resign his office by submitting his resignation letter to the President. Okay, and a judge of the Supreme Court cannot be removed from office except by an order of the President on the ground of proved misbehavior or incapacity. Such an order is passed after an address by each House of Parliament, supported by a majority of the total membership of that House and by a majority of not less than 2/3 of the members of the House present and voting. For such a removal, this procedure is known as impeachment. Already we have heard, no? Parliament of India can impeach the judges of the Supreme Court from their office, but there should be reason. Okay? Please remember impeachment. What is impeachment? Okay. And now we will learn about the important topic. You will learn about the jurisdiction and the powers of the Supreme Court of India. Jurisdiction means power to make legal decisions and judgment. Power to make legal decisions and judgment. That is the meaning of jurisdiction. And the powers of the Supreme Court. We are going to learn about the various powers of the Supreme Court. Okay, jurisdiction is the power that a court of law exercises to carry out judgments and enforce laws. The Supreme Court is the protector and the final interpreter of the Constitution, one who explains. Okay, interpreter. It has both original and appellate jurisdiction as well as advisory jurisdiction. Okay, appellate and advisory. Original, appellate, advisory, revisory jurisdictions are there. One by one we will learn. So what do you mean by original jurisdiction of the Supreme Court? It means the power to hear and determine a dispute in the first instance. That is, those cases which cannot be moved in any other court other than the Supreme Court. So this is known as the original jurisdiction of the Supreme Court. Original jurisdiction of the Supreme Court means Supreme Court of India has the power to hear and settle some cases in the first chance. Or we can say some cases in India will reach directly in the Supreme Court. For example, if there is a dispute between Government of India and one or more states, this case will go to the Supreme Court directly. or between Government of India and any states or states on one side and one or more states on the other, and between two or more states. So if there is a dispute between states in the country, if there is a dispute between union government in one side and two or three state governments on the other side, that case will go to the Supreme Court directly. Okay, please remember. And this has, exception A, this jurisdiction shall not extend to a dispute arising out of a treaty, agreement, etc., which is in operation. In certain other matters such as interstate water disputes, matters referred to the Finance Commission, and adjustment of certain expenses and pensions between the Union and the states. In order to solve this case, the Supreme Court can establish special tribunal. For example, Kaveri Water Tribunal, a special court to solve the issues between 5 states in the country regarding the sharing of the water of the Kaveri River. Okay. And now second case in this category, protection of fundamental rights. The original jurisdiction also extends to cases of violation of the fundamental rights of individuals, and the court can issue several writs for the enforcement of these rights. Any individual can approach the Supreme Court in case of violation of a fundamental rights. What do you mean by writ? Writ is an order of a court. In our country, the Supreme Court of India and the High Courts can issue these writs, like habeas corpus, certiorari, writ of prohibition, mandamus, and quo warranto are the 5 writs. Okay. And third case, transfer of cases from lower courts. Under Article 139A, inserted by the 44th Amendment Act in 1978, the Supreme Court may transfer to itself cases from one or more high courts if these involve questions of law or cases are of great importance. Okay. The Supreme Court may transfer cases from one high court to another in the interest of justice. Okay. So, in the original jurisdiction, Supreme Court has this power to transfer cases from one court to other. Interpretation of Constitution. All cases where interpretation of the Constitution is required can be directly filed in the Supreme Court. Interpretation means explanation of the Constitution if there is a doubt regarding any article of the Constitution. Okay. The Supreme Court has the power of exclusive jurisdiction in regard to questions asked to constitutional validity of central laws. You will learn this power. Supreme Court of India has the power to review the laws made by the government. Okay, that we will learn afterwards. So listen, what do you mean by original jurisdiction of the Supreme Court? Meaning you have to learn. And the cases in this, what we can say, cases in this category. And now, appellate jurisdiction. What do you mean by appellate jurisdiction? Appellate jurisdiction means the powers to grant special leave to appeal against judgment delivered by any court in the country. Okay, what do you mean by special leave? A special permission to a party to appeal in the Supreme Court. That is the meaning of special leave. It is a special permission to a party from the Supreme Court to appeal in the same court. Okay, appeal means Supreme Court. Okay, it is a court of appeal, which means that it is a court which may change the decision or reduce the sentence passed by the lower court. From the high courts of our country, appeal will go to the Supreme Court, or Supreme Court has the privilege to accept appeal from the lower court, means from the high court. The Supreme Court is the final court of appeal. An appeal lies to the Supreme Court from any judgment or final order of a high court in India. The appellate jurisdiction extends to constitutional, civil and criminal cases. Appellate, no. Appeal in the form of appeal. Okay. In the constitutional cases, all matters irrespective of the nature where a certificate is issued by a high court that it involves an important point of law and needs interpretation of the constitution. Explanation of the constitution can be brought before the Supreme Court. If the High Court refused to give a certificate on such a case, the Supreme Court can grant special leave of appeal. Okay. So these cases will reach in the Supreme Court in the form of appeal, means constitutional cases. And civil cases, appeals in civil matters lie to the Supreme Court if the High Court certifies that the case involves a substantial and important question of law of general importance and that the question needs to be decided by the Supreme Court. Then the High Court will give the permission to appeal in the Supreme Court. However, if the High Court refuses to give a certificate, Supreme Court can grant special leave to appeal in the suitable cases. And in criminal cases, appeal will go. Two types of appeals in criminal cases lie in the Supreme Court. Cases without the certificate of High Court, cases with the certificate of High Court. Two types of cases, in criminal cases. The certificate of the High Court is not required in a case where the High Court has reversed the judgment of acquittal given by the lower court and punished the accused with a death sentence. That case will go to the Supreme Court in the form of appeal. For this, there is no need for a certificate from the court. A case which is withdrawn by the High Court from a subordinate court and sentenced the accused to death. Okay? Please remember, accused to death. This case will go to the Supreme Court in the form of appeal without a certificate. In no other criminal cases, a High Court certification that the case involves a substantial point of law and interpretation of the Constitution is required for appealing to the Supreme Court. Okay? So we have read about the appellate jurisdiction of the Supreme Court of India. What do you mean by that? So the Supreme Court has the privilege to accept appeal from the lower court. Okay? That is known as appellate. The powers to grant special leave to appeal against the judgment delivered by a court in the country. Okay? So what do you mean by special leave? A special permission to a party to appeal in the Supreme Court. Okay? And now we will learn about the functions of Supreme Court. We all know what is the main function of this court now. Court has to see the cases and settle the cases. No? Okay. In order to settle the case, the court will follow original and appellate jurisdictions. Okay. The Supreme Court has the original jurisdiction to settle disputes between the central government and one or more states and union territories, as well as between different states and union territories. Besides, it has original jurisdiction with regard to the enforcement of fundamental rights, transfer of cases from high courts and interpretation of the Constitution. It means Supreme Court will accept appeals from the lower court. Okay, we know that already we have learned. Supreme Court has the original jurisdiction. No, original jurisdiction. What do you mean by original jurisdiction? Some cases will reach the Supreme Court directly. Already we have learned. No, and the Supreme Court will settle these cases according to the original jurisdiction. Okay. And some cases will reach in the Supreme Court in the form of appeal. The Supreme Court deals with appeals which are made to it in respect of its original jurisdiction. It gives its verdict on the interpretation of the Constitution. It also settles interstate or universal disputes. So, dear students, we will continue it on tomorrow. Again, the functions of the Supreme Court. One more video I will upload on tomorrow. So, please revise and learn the lessons. Okay? Thank you.